The dining room had been tense for years, but Thanksgiving 2024 was when everything finally shattered. I'm a corporate attorney specializing in estate planning and family trusts, so I know exactly how family dynamics can twist around money and control. But I never thought I'd have to use my professional expertise against my own mother. My name is Michael, and my mother, Karen Whitmore, had always been opinionated. But somewhere around 2016, her political views didn't just intensify, they became her entire personality. Every family gathering turned into a lecture. Every phone call became a recruitment effort. My kids, 15-year-old Emma and 17-year-old Josh, had grown up with a grandmother who sent them birthday cards with political cartoons inside and Christmas gifts that came with pamphlets. But this Thanksgiving, she crossed a line I didn't know existed. Karen, sitting at the head of the table, pointing her fork at Josh, "You're almost 18, Joshua. You need to understand what's really happening in this country. These schools are brainwashing you. Your teachers are all radical leftists trying to turn you against your own family, against your own heritage." Josh had barely touched his sweet potatoes. Emma was staring at her plate, her jaw clenched. My wife, Jennifer, reached under the table and squeezed my hand, a silent plea for me to intervene. Before you continue with this story, if you're enjoying the drama, make sure to hit that like button and subscribe to Karen E World. Trust me, you won't want to miss how this unfolds. Now, back to the chaos. Josh, quietly, "Grandma, I just said I wrote an essay about climate change for my environmental science class." Karen, her voice rising, "Climate change? It's a hoax, Joshua. A complete fabrication designed to control you, to take away your freedoms. And they're starting with children, because children are easy to manipulate." Emma, suddenly looking up, "I'm not being manipulated, Grandma. I can think for myself." That's when Karen made her fatal mistake. She turned to my daughter, my brilliant, compassionate, straight-A student daughter, and said the words that would eventually cost her everything. Karen, leaning forward, "No, sweetheart, you can't. Not yet. Your brain isn't fully developed. You're being used as a pawn by dangerous people, and your parents are letting it happen because they've been brainwashed too." The table went silent. Jennifer's hand tightened around mine. Josh pushed his chair back slightly, ready to leave. But it was Emma who spoke, and her voice was shaking not with fear, but with rage. "Emma, standing up, I don't want to see you anymore, Grandma. I don't want your birthday cards. I don't want your Christmas presents. I don't want to hear your voice. You don't respect me. You don't respect Dad. You don't respect any of us." Josh, standing up beside his sister, "I'm with Emma. I'm done." I expected Karen to backtrack, to apologize, to show some shred of the woman who had raised me. Instead, she smiled. Actually smiled. Karen, folding her napkin, "Fine. Cut me off. But when you turn 18, Joshua, you'll inherit your share of the family trust. $25,000. And I'll be there to make sure you understand what to do with it, whether your father likes it or not. You'll see the truth eventually." That's when I realized this wasn't just about politics anymore. This was about control. The family trust she was referring to had been established by my late father, her husband, 20 years ago. It was a relatively small trust by my standards, designed to give each grandchild $25,000 when they turned 18. Karen was the trustee, a role my father had given her assuming she'd remain the reasonable woman he'd married. But my father had died in 2019, before Karen's transformation into someone we barely recognized. Over the next few months, the situation deteriorated. Karen began sending Josh letters, thick envelopes filled with printed articles from fringe websites, handwritten notes about how she was going to help him invest his trust money properly when he turned 18 in June. She sent Emma emails, dozens of them, explaining that she was only trying to save her from a lifetime of being deceived. My kids were stressed. Emma's grades slipped. Josh started having anxiety attacks. Jennifer and I blocked Karen's number on their phones, but she found ways around it. She created new email addresses. She sent packages to their friends' houses. She even showed up at Josh's school one afternoon, waiting in the parking lot to have a conversation with him. The principal called me immediately. I arrived to find Karen arguing with the vice principal about her First Amendment rights. Karen, her voice echoing across the parking lot, "I have a right to speak to my own grandson. This is America. You can't keep me from my family." I had to threaten legal action to get her to leave. That night, I sat in my home office, staring at the trust documents my father had created. As an attorney, I knew these documents inside and out. I'd helped my father draft them, actually. And I knew something Karen had apparently forgotten. The trust document contained a clause, common in family trusts, allowing for the removal and replacement of a trustee if they were deemed to be acting against the best interests of the beneficiaries. The clause required a petition to the probate court, evidence of misconduct, and approval from a judge. I spent 3 weeks building my case. I documented every letter, every email, every unwanted package. I got statements from Josh's school about the parking lot incident. I had Jennifer write a detailed account of Thanksgiving and the month that followed. I compiled medical records showing Josh's anxiety had spiked, including his therapist's notes that specifically mentioned stress from his grandmother's harassment. Then I found something even better. In her zeal to educate Josh about finances, Karen had been sending him detailed emails about how she planned to direct his trust distribution. She wanted him to invest in specific companies, all of which aligned with her political views. She'd even contacted several investment firms on his behalf, using her position as trustee to set up preliminary accounts. This was a clear breach of fiduciary duty. As trustee, she was required to act in Josh's best interest, not use the trust as a vehicle for her own agenda. But removing her as trustee wasn't enough. I wanted consequences. Real ones. The kind that would make her understand that actions have repercussions. So I did something I'd been considering for months. I contacted my father's estate attorney, Gregory Chin, one of the best probate lawyers in the state. Greg had been my mentor when I first started practicing law, and he owed me several favors from cases I'd referred to him over the years. "Greg, sitting across from me in his corner office downtown, Michael, you know I loved your dad. And I've seen what Karen's become. It's heartbreaking. Let me ask you something, though. Do you want to just remove her, or do you want to make a statement?" Me, leaning forward, "I want my kids to never have to deal with this again. And I want her to understand that harassing children, even her own grandchildren, isn't consequence-free." Greg smiled, the kind of smile that made opposing counsel nervous in depositions. "Greg," pulling out a legal pad, "then let's talk about surcharge." Surcharge. In trust law, it's a beautiful thing. When a trustee breaches their fiduciary duty, they can be held personally liable for any damages caused by that breach. This can include emotional distress, therapy costs, and even punitive damages in egregious cases. We filed the petition in probate court on a Monday morning in March. The petition requested Karen's immediate removal as trustee, the appointment of a professional corporate trustee to replace her, and a surcharge hearing to determine damages caused by her misconduct. The court scheduled an emergency hearing for the following week. I didn't tell Karen it was coming. The sheriff's deputy served her with the court papers on a Wednesday afternoon. According to the deputy, who I'd worked with on previous cases, she'd answered the door in her bathrobe, taken the papers, and immediately called me. I didn't answer. I was in a deposition. She called 17 more times that day. She left voicemails that ranged from confused to angry to threatening. By evening, she'd apparently hired an attorney, some solo practitioner who advertised on bus benches. The hearing was everything I'd hoped it would be. Greg presented our evidence methodically. The letters, the emails, the school incident, Josh's therapy records, which we'd gotten his permission to enter into evidence. Emma even wrote a victim impact statement, which Greg read aloud to the judge. Karen's attorney tried to argue First Amendment rights, family privacy, and grandparents' rights. Judge Morrison, a no-nonsense woman in her 60s, who'd been on the probate bench for 20 years, was unimpressed. Judge Morrison, looking over her reading glasses at Karen, "Mrs. Whitmore, you are appointed trustee of a family trust. That position comes with legal obligations. One of those obligations is to act solely in the best interests of the beneficiaries. You have used your position to harass your grandchildren, to push your personal agenda, and to cause them documented psychological harm. This is one of the clearest cases of trustee misconduct I've seen in my career." She granted our petition in full. Karen was removed immediately. A corporate trustee was appointed. And then came the part I'd been waiting for. Judge Morrison, continuing, "Furthermore, I'm ordering a full accounting of the trust and scheduling a surcharge hearing for May 15th. Mrs. Whitmore, you are ordered to appear and show cause why you should not be held personally liable for damages including but not limited to therapy costs, emotional distress, and punitive damages." Karen's face went white. Her attorney leaned over to whisper something to her, and I saw her shake her head violently. But I wasn't done. Not even close. You see, the trust wasn't the only legal connection between Karen and my family. When my father died, he'd left his house to Karen with a life estate, meaning she could live there until she died, at which point it would pass to me. It was a lovely house in a quiet neighborhood, paid off, worth about $600,000. But life estates come with conditions. The holder of the life estate is responsible for maintaining the property, paying taxes, and not committing waste, which means not damaging or devaluing the property. I'd driven past Karen's house a few weeks earlier and noticed something interesting. Her front yard, which had always been meticulously maintained by my father, was now covered in political signs. Not just a few, dozens of them. Large ones. The kind campaigns use at rallies. There were banners hanging from the porch. Flags on poles. The house looked like a campaign headquarters. I took photos. Lots of photos. Then I checked the neighborhood HOA rules, which my father had always followed carefully. The HOA allowed one political sign, no larger than 2 feet by 3 feet, during election season only. Election season was defined as 60 days before an election until 7 days after. It was now March. The next election wasn't until November. And Karen had approximately 40 signs in her yard, some of them 8 feet tall. I sent a formal complaint to the HOA, not as her son, but as the remainder holder of the property, with a vested interest in maintaining its value. The HOA sent her a violation notice. She ignored it. They sent another. She responded with a letter about her constitutional rights. The HOA fined her $500. She refused to pay. The fines began accumulating at $50 per day. Then I discovered something even more interesting. Karen had, apparently in a fit of political passion, painted a massive slogan across her garage door. The paint was permanent. The slogan was, well, aggressive. And the garage door was original to the house, a custom wood door my father had commissioned from a craftsman. This was waste. Clear, documented waste. She was damaging the property, reducing its value. I filed a petition for waste in the same probate court. Judge Morrison again. The May 15th hearing became a double feature. Surcharge for the trust breach, and waste for the property damage. Greg and I presented our case like a surgical strike. For the trust surcharge, We had receipts for Josh's therapy, $3,000 and counting. We had documentation of Emma's declining grades and the cost of the tutor we'd had to hire, $2,000. We presented expert testimony from a child psychologist about the long-term impact of familial harassment. Priceless, but we assigned it a value of $10,000 for emotional distress. Then we asked for punitive damages, $50,000. The purpose wasn't really to get the money, though that would be nice. The purpose was to send a message that you cannot use a position of trust to harm children. For the waste claim, I presented photos of the property, an appraisal showing the damage to the garage door and overall curb appeal had reduced the property value by approximately $30,000, and a contractor's estimate to restore everything, $45,000. Karen's bus bench attorney was out of his depth. He sputtered about freedom of speech, about Karen's rights as a life tenant, about family disputes being settled privately. Judge Morrison was not sympathetic. Judge Morrison, her voice cold, Mrs. Whitmore, you have abused every position of trust you've held. You've harmed your grandchildren emotionally and psychologically. You've damaged property you don't own. You've accumulated HOA fines that are now approaching $15,000. I'm granting this surcharge petition in full. You are personally liable for $65,000 in damages related to the trust breach. I'm also granting the waste petition. You are liable for $45,000 in restoration costs, and I'm issuing an injunction requiring you to restore the property to its original condition within 90 days or vacate the premises. Karen stood up, shaking. Karen, her voice breaking, this is my home. My husband left me this home. Judge Morrison, firmly, your husband left you a life estate with conditions. You violated those conditions. You have 90 days. Court is adjourned. The total judgment against Karen, $110,000, plus the ongoing HOA fines. Karen didn't have that kind of money. Her only significant asset was her life estate in the house, which she couldn't sell because she didn't own it outright. She had two choices: take out a reverse mortgage or home equity loan to pay the judgments, which would eat up any remaining equity, or vacate the property and let me deal with the restoration and sale. Either way, her position of power was gone. The trust was managed by professionals. The house was no longer her fortress. Her grandchildren had legal protection through court order. I saw her one last time, 3 weeks after the hearing. I'd driven past the house to check if she was complying with the injunction. The signs were still up. The garage door was still painted. She was sitting on the front porch, surrounded by all her political paraphernalia, staring at a letter in her hands. I later learned it was from a bank, denying her application for a home equity loan. Her credit wasn't good enough, and the property had too many liens against it now. I pulled into the driveway. She looked up at me, and for just a moment, I saw recognition flash across her face. Not of me as her son, but of what I'd done. How I'd used her own actions, her own choices, her own abuse of power against her. How every nasty letter she'd sent, every harassing email, every violation of her duties had been carefully documented and turned into legal ammunition. She'd weaponized family relationships and positions of trust. I'd weaponized the law. Karen, her voice barely a whisper, you did this. You actually did this. Me, calmly, no, Mom. You did this. Every bit of it. I just made sure there were consequences. Her face cycled through emotions: confusion, anger, denial, and finally, devastating comprehension. She understood. The trustee position she'd planned to use to influence Josh, gone. The house she'd turned into a political statement, about to be taken. The money she'd have to pay, more than she had. The grandchildren she tried to control, legally protected from her. She tried to use every bit of power she had, family, property, money, to force her views on children who just wanted a normal grandmother. And in doing so, she'd handed me everything I needed to dismantle that power completely, legally, permanently, and devastatingly. The look on her face as she realized the full scope of what had happened, how thoroughly she'd been outmaneuvered by her own son using nothing but her own actions against her, was something I'll never forget. If you made it to the end of this epic saga of legal revenge, smash that like button and subscribe to Care and Eat World for more stories of entitled people getting exactly what they deserve. Thanks for watching, and remember, sometimes the best revenge is just letting people face the consequences of their own actions.